All right, as people are making their way back to the seats, we'll get started with the, I guess I don't know if this is the first or second panel that we're doing, but again, my name is Mike Sheetzelt. I'm a legal fellow with the John Locke Foundation, and I was brought on specifically for this project for recodification. If you look at the agenda that we've handed out, the title of this panel is just a stakeholder forum. And what we'd like to do is we'd like to allow stakeholders in the criminal justice system right now to speak about some of the issues that they see with the criminal code or the current state of affairs of our criminal justice system, specifically on the substantive criminal laws. So without any further comment from me, I'll introduce our panelists. Starting from my right is Lauren Freeman, is District Attorney of Wake County. And I will allow each of these individuals to introduce themselves a bit more fully if they so desire. In the middle, we have Stephen Walker, who is with the Lieutenant Governor as his General Counsel and Chief of Staff. And closest to me is Eddie Caldwell with the Sheriff's Association, representing law enforcement on this panel. So with that, Lauren, if you'd like to.
Sure. Good morning. Thank you, folks. It's an honor to be here, especially across the room and see so many friends that I've worked with in various capacities over the last 20 years. It's been a very interesting process the last few years for those of us who have labored in the criminal justice system. There's always been kind of the interest in the crime that occur. Certainly shows like Law and Order, always drawn a huge audience, and it's always been said that it leads is the news. I think what's different about what's going on right now is certainly very welcome for those of us who work in the criminal justice system. Is a very diverse community interest in the policies and processes and procedures that underpin the work that we do. And so I appreciate y'all's interest and ability to be here today. I thought, when I walked into my office this morning, I've got sitting on the corner of a table in my office. I've kept it now for over 20 years. My sister gave this to me when I finished law school, and it's a print from the New Yorker magazine. It says Law Library, and you can see all the different books on the Law Library, and it says it's frightening when you think that we started out with just 10 commandments. I think that's a good illustration, really, of where we are. And of course, we could fill many, many, many more shelves than just this picture would show. I told Professor Jessie Smith I was going to borrow heavily from some of the great work that she's done on the issue of overcriminalization and certainly kind of the state of the criminal code. I think from a prosecutor's perspective, when you think about all of the different sources of criminal violations, and certainly in a vast majority of the more arcane rules are not things that we typically see in court. And yet, when you think about all the many, many different chapters across all the general statutes, all of the different violations, throw in certainly the regulatory violations and ordinances of towns across state, I think it can be very difficult, both from a prosecutor and law enforcement standpoint, to really know what the full breadth of that net is. We try to focus clearly on those things that are most common and focus on making sure that those laws that are really important to our communities are the ones that we are holding people accountable for. But I think that certainly when you think about some of the confusion that is wrought inside a vast number of different statutes, different regulations that we have, that certainly figuring out a way to simplify that is important. Having said that, I think for all of us sitting up here today, I think part of what you're going to hear is that the risk or the rush to do some of this needs to be done in a way that certainly preserves public safety and certainly preserves our ability to keep our community thriving and safe. And so I look forward to continuing this conversation.
Right. We got our courts and our criminal justice system. We have anybody from Swain County here? Anybody come all over from Swain County? Everybody from Dick County? I know we have at least one. So I'll just do this in the back. So we do have one from Dick County. In 2011, I was practicing criminal law in John County, and I got appointed a case, and I grabbed the file for it to go meet with my client who was down in jail. And I looked, and he had been charged with a violation of 14-197, which I'll talk a little bit more about in a minute, but that was using profane language on a highway or a public vehicular area in the hearing of 2 or more people. And I said, okay. So I grabbed that statute and went and started doing some research on it, and I found out something interesting, that the last sentence of the statute said, and this statute does not apply in Pitt and Swain counties. So apparently in Pitt and Swain counties, you can cuss people all you wanted on the road. Thankfully, that statute was repealed in 2015. I wrote a blog post about it back in 2014 on the Lieutenant Governor's website, and everybody kind of got a good chuckle out of it. The Pitt and Swain County were there. Our court, district court judge, probably didn't know what to do when I was in there arguing equal protection. And also arguing First Amendment protections. Really what had happened is my client was at the hospital. He was walking across the parking lot to go to the pharmacy. At night, an officer said to him, an officer with some other people around, said, hey, how's it going? He responded with, F you, that's how it's going. My client did not like law enforcement. Unfortunately for him, that ended up being then a resisting after that, and then some destruction of property on the way in the car. It just ended up being a lot of things that went on there. But I think most people wouldn't have thought that it was illegal to say a bad word on the highway. If you just say to one person, you're okay, but if 2 people can hear it, it's trouble. But like I said, that law's been repealed now, and so there has been at least some work done on that. Just the sheer volume of criminal law that we have makes it difficult for a lot of stakeholders across many chapters. Then that's, you can put on top of that the municipal ordinances, the county ordinances, the agency rules that have got the force of criminal law. You just have a lot of issues that arise out of that. And I think if one thing in our law should be clear, it should be our criminal law. That should be the one thing that should be clear, because life and liberty are at stake. So it needs to be clear. And if trained lawyers sometimes can't figure out where the statute is and what it is, that's a problem. Because how do we expect the people that do not have legal training, the laymen, if you will, to be able to follow the law? A lot of times that this confusion that we have with so many different crimes that can be attached to one act is you can have overcharging. An example of that would be if you have a bad check. You write a bad check, and there's different tier levels of bad checks that you write, a worthless check, and if you knew that there wasn't any money in the account, it's one thing, and then there's all these different times. But I've seen that charged a whole lot of times. I've seen that charged as obtaining property by false pretenses, which bumps that way up. Now, it's not always a bad idea to overcharge. To charge for something and trying to get a plea deal. I understand what prosecutors go through every day to try to get those dockets moving, because there's a lot on there. And so I understand that happens a lot of times. But if you think about it, the General Assembly, and therefore, in theory, the people, have said this is the punishment that we want to attach to this certain crime. We want to punish it at one level, and we make it specific. But then when we take something that is more general and we increase the punishment over what the specific crime was, you can see how that can cause some issues with people being charged with more than what the people expected them to be charged with or even convicted. It's a burden on taxpayers when we have a criminal law code that's a mess like it is. Both in accidental violations that we talked about, cited overfederalization, as you saw in North Carolina. We make a new law that's like it needs to be a felony. We have to really seriously think about that, because sometimes it does need to be a felony. Sometimes it doesn't. So it's something that we really have to think about. It causes increased costs in law care. How hard it is to get a job when you're a felon. It's very difficult to do that. So it increases those things, even if they say, well, you're not eligible for certain types of welfare assistance if you are going to develop a legend. People still have families, and that's another thing that you're saying for it. So those other folks might be eligible for that government assistance. It's a burden on I don't want to have to look in 45 places, and I need to look to make sure that I'm following the law. And then also, it's a burden on law enforcement. It's hard to enforce something that's so complex. It's a burden on attorneys, both defense attorneys and district attorneys, and it's a burden on policymakers. I can't tell you the number of times that I've talked with people in the legislature, and we sat around and said, are we sure this isn't already a crime? Are we sure this isn't already, because we don't even know. And we've been dealing with it for a long time. So, as he said, I am the Chief of Staff and General Counsel for the Lieutenant Governor, and that's really where the position that I come from is that we want to make this better for everybody, for all the stakeholders involved, because every person inside the boundary of North Carolina is a stakeholder when it comes to our criminal law, because it can impact everyone. So, thank y'all for coming.
Thank you for the opportunity to be here today representing the North Carolina Sheriff's Association and speaking on behalf of law enforcement in general. There's a lot of examples in given today through the discussion about particular laws that everyone would agree needs some attention, needs some recodifying or have to be and so forth. But there's some other angles that apply to this whole process. It's not just a matter of looking at the laws and seeing which ones folks think make sense and necessary and they don't. One of the things that this project needs to look at, those that are going to go forward with it, is the interplay between different statutes and how that creates a practical problem for not only our citizens, but for our law enforcement officers that have to enforce the law. We had a tremendous controversy and crisis in North Carolina a number of years ago when a hurricane was headed to the coast, but not yet near enough to the coast to create weather problems, more than just a little bit of rain, and the governor declared a state of emergency. There's a statute that says it's unlawful to carry a firearm off of your own premises during a declared state of emergency. In the mountains, it was beautiful, and dove season was 2 days away from opening. So you've got the wildlife law that says you can only hunt dove on during certain days of the year and under certain circumstances. You've got the well-intentioned law that says you can't carry a firearm off of your own premises during a declared state of emergency. But because the governor declared it for the whole state, that created a great problem. Well, it didn't create a problem for anybody in Raleigh, but for the sheriffs and the hunters and those in western North Carolina, it created a major problem because nobody felt like the hunters, there was going to be an uprising if they couldn't start dove season on time. The sheriffs didn't want to be out arresting all the dove hunters on a pretty day because there might be a storm 3 days off the coast of North Carolina. So how the different statutes interplay with each other needs to be looked at closely. Another challenge for law enforcement is the availability of legal counsel. Professor Smith's got the North Carolina Crimes book there in the supplement that everybody's familiar with, which is a tremendous, it's the go-to book for law enforcement officers all across the state. So much so, as she pointed out earlier today in the conversation, that those that have mobile data terminals or computers in their cars want to have it on their computer so that they can look these things up. But they don't have ready access to legal counsel. So if the law is not clear, and if the applicability is not clear, then it makes it very difficult on law enforcement officers to enforce it or to make the determination that it shouldn't be enforced in a particular circumstance because it doesn't apply. Other practical, a couple of examples of the practical problems that law can create if it's not clearly written and clearly defined. One is, if you look at all the statutes on when and where you can carry firearms, it's very complex, it's very spread out, so it's very difficult for citizens to know where they can carry firearms off their own property, and very difficult for law enforcement to know and be able to enforce that. Something as simple as sex offender registration. Sex offenders can go within 1,000 feet of certain schools and other facilities, but there's no clear guidance initially in the statutes on how you measure that. So where does 1,000 feet start being measured? And it's felony for a sex offender to move within those prohibited distances. So in looking at what ought to be criminal offenses, what ought not to be, the applicability of it ought to be evaluated as well. One of the things that folks sometimes lose sight of is law enforcement officers don't want to charge folks with crimes if the person didn't commit a crime. And sometimes it's hard for the officer to determine that. When I first started out in my career, I was a Carborough police officer, and there was an issue with the sign that a restaurant had put on a sort of canvas sign. They had draped over a car parked out in the parking lot, and there were folks that wanted us to charge the business owner with violating the sign ordinance. Being not a lawyer at that time and not clear on whether it was a violation or not, I went to see the magistrate, explained the circumstances to the magistrate, and the magistrate said very candidly, I don't know about all that, but if you want a warrant, I'll give you one. Well, I didn't want a warrant. I wanted to know if it was a violation or not. The magistrate said, so I didn't know whether they asked for a warrant or not. Because I didn't want to charge this business owner if it was a violation. Other things that could be made clearer in law that help law enforcement and help the public are some practical provisions, such as we had a lot of discussion here in the Research Triangle on various occasions, including last week, about statutes and who can climb on the statute, who can make a statute, who can tear a statute down, whether the statute ought to be moved. Well, the people that get involved in all that are law enforcement officers who are standing out there trying to keep this group from that group, protect property, protect everybody's rights. Something as simple as a requirement that the statute has a small fence around it. I'm talking about a decorative fence, not a chain link fence. Then it would be unlawful to go inside that fence. Well, that makes it very clear for the officer on the street that as long as those are exercising their constitutional rights, an appropriate distance from statute, then they are not violating law. But once they go inside that perimeter, then that's a trespass violation in and of itself, and it makes it very clear for the officers who are on the front lines to carry out the public policy that's been enacted by the General Assembly. And in this whole process, the one group that should not be overlooked, and that is the victims. And I haven't heard the word victim mentioned all morning this morning, but that is critical. And the folks who initially have to deal with and provide services to the victims are the law enforcement officers. Then if charges are made, then that kicks up to the district attorney's office. But so many times, law enforcement officers are dispatched to a situation and somebody wants the officer to do something. And when I say do something, they're not worried about is it a felony or a misdemeanor or what you do. They just want whatever is bothering them or annoying them stopped. And the main resource that law enforcement officers have to give them some relief is to charge the offender with a crime and remove the offender from the situation. But if there were other resources available, neighborhood disputes, for example, if they could go to dispute resolution instead of going through the criminal court system, then maybe both parties could get some relief without it being a crime. But in the final analysis, many of our statutes, some of which have been laughed about today, came about because of a citizen who was a victim of some conduct, thinking that there needed to be some relief for those. And I mentioned just one that I'm shocked it's not been mentioned here up until now today, and that is largely time control being felt. And so now we get to well, that was enacted at the request of the citizens and the sheriff of Warren County, because time control, it doesn't just show up with the bells in the back of that truck loads on the Depot. It actually falls from trees, has to be gathered and bailed up. And they were having a big problem in Warren County with folks coming in and stealing the entire crop of the pine straw. And so that's how that became a felony. But could it be a felony in some other statute, or could it be dealt with in some other way? Those are the kinds of things that I hope that this discussion goes forward. Those issues we look at as part of not just, does that sound like a silly statute, but what was the underlying reason that got enacted and what we do. So from a law enforcement perspective, the statutes need to be clear and understandable. They need to provide protection for the victims, and there needs to be some focus on them being easy to apply out in the street Saturday morning, 3 o'clock in the morning when it's raining and everybody's not sitting in a nice environment like we're in here today.
I think that's a good segue into my first question, and this is for you, Eddie, specifically, although anybody's free to answer it. It's how does you talk about how a lot of times there's uncertainty on the part of the officer in terms of how to respond to certain calls. How does this impact the relationship between law enforcement and communities? And that's been a hot button issue now for a number of years. And public trust and confidence in our institutions is incredibly important to maintain the rule of law. How does this undercut that, or does it undercut that public trust and confidence in law enforcement?
Well, a lot of times when you have an officer responding to the scene, it's sort of similar to what I talked about earlier. That is, you have a dispute between parties, and one party wants something done, the other party doesn't want something done. If the law was clear and the applicability was clear, then it would make it easier for the officer to explain it to the parties, and then hopefully the parties will understand the officer's doing their job, carrying out the law as it's been enacted.
I think anytime, we see, and you catch these news stories periodically where, there's been somebody charged with what is one of these relatively arcane or unusual statutes, and there's no question that there becomes kind of this social media frenzy or around it, and it's almost a joke, and it certainly undermines the public perception of the criminal justice system, and in fact, it really got serious business.
And one thing I'll add is most of the news coverage now doesn't get in depth in analyzing the situation. So it's easy to laugh at large crimes are always felony if you don't understand the problem that was designed to solve. And so when you talk about people being charged with a particular offense, we never get, as Paul Harvey used to say, the rest of the story. We just get the sound bite. Sometimes the tagline at the bottom says more to come, but more never comes.
Right.
And the analysis is never there. And so the public looks at that and thinks, well, the law enforcement officer, the court system, the DA, whomever, sure handled that one wrong, but the reader doesn't know the whole story.
I think a perfect case in point was the story out of Garfield Heights, Ohio, maybe a month or two ago, about the woman who was arrested for feeding feral cats. Of course, they didn't really mention it. You had to get down about halfway into the story to find out it was for contempt of court because this was her third or fourth time violating this ordinance. But still, it's 10 days in jail for a 79-year-old woman for feeding feral cats. I want to go back to Stephen's point about the statutes that don't necessarily have uniform applicability. You talked about the profanity statute. There's ordinances, as we mentioned earlier, more than 650 criminal jurisdictions essentially in North Carolina. And there are still statutes on the books. That one's been repealed, but there's the obtaining an ambulance fraudulently. There are two different statutes on that. They apply in a total of 53 different counties. One of them applies one county has both of the protections offered by these two statutes. Haywood County falls in both of these statutes. How much does that lack of uniformity impact defendants, victims, law enforcement? How difficult does it make this to administer the laws as an attorney, as a defense attorney, as a prosecutor, and again, as law enforcement?
Well, I think one of the things that you want to ask yourself is, if this law isn't good enough for all 100 counties in North Carolina as a crime, then why is it going to be a crime in any of the 100 counties of North Carolina? And, another one that was discussed in the legislature probably 4 or 5 years ago had to do with BB and pellet guns. And I just remember multiple people attaching their counties on to make it legal for people to be able to have a BB gun in their car or whatever it was. And you do that. And I think that's really the question that we have to ask is, why would this be a criminal statute that the legislature is passing in some counties and others? I understand the idea of local bills and the necessity for that, but I think it should make us at least stop and ask ourselves the theoretical question and just the practical question: should this be a crime? If it's going to be a crime in, the legislature says, well, this is a crime in Henderson County, but it's not in Buckingham County. This is a crime in Johnston County, but it's not in Lake County. I think you'd have to ask yourself is, should this be a crime anywhere or everywhere?
Right.
one of the things that this state really has been a cornerstone of our criminal justice system for over 20 years now is structured sentencing, and the way that we kind of sentence defendants, they are convicted, and the ability to project prison populations as a result of that. And part of the work with the Sentencing Commission, one of the things they are required to do any time that a bill is introduced in the legislature is to look at, what is the prison impact of that, and how does that fit into kind of the classification of crimes. It strikes me that, as we've talked about, in many instances, and they are all well-meaning, but in many instances, as Eddie was saying, we have new crimes on the books because someone recommends something. There's a constituent or someone feels like something is a major issue. And one of the things that I think would help in trying to look at whether that is a necessary law is for someone like the Sentencing Commission or the Juvenile Statute Commission to also publish something or do, for the Sentencing Commission, it's a fiscal note, but some sort of analysis that says, this kind of conduct is already punishable under all of these offenses. And I think that would help educate people as to what is already on the books and maybe slow a little bit of the desire to, just enact a new statute or something.
Turning to the I guess the issues faced by prosecutors. There are a lot of laws out there. A lot of them aren't very clear. And I guess as a clerk at the appellate courts, we've seen a lot of indictments overturned on certain technicalities. What kind of challenges does this present to prosecutors? Is there trying to draft indictments, decide what to charge, and keep the docket moving? How does this impact your work and your assistant district attorneys?
I think what's really interesting about this concept of such a diverse criminal code is that, as I sit here and think about it, every year the Administrative Office of Courts prepares a report that tells us the number of charges by offense code. And there is an offense code, for pretty much all of these different statutes that we're talking about. And for many of them, if you were to go through and look at that list, you're looking at less than 5, and in many instances, 0 charges for certain parts of the code. I think we tend to stick to pretty common offenses as a general rule. I do think that it does, though, open up the opportunity for confusion or frustration by a victim who, may, because everybody has access to Google now, they look up a particular statute, a particular crime, and they want to know, why are we not, this crime seems to fit, and why aren't we pursuing that particular crime instead? And I think that, certainly simplifying some of that would be helpful. I'll tell you another interesting thing that's, not the same, because I think you can look at, overcriminalization from a number of different perspectives. Certainly, part of what we're talking about is the complexity of the criminal code, but I think we've also kind of hit upon a little bit, the issue of overcharging or bringing charges where there may not be a need to bring charges. I was at my family reunion this weekend in Sterling County, and a cousin of mine, as it turns out, is a prosecutor in Virginia, and we were having this conversation that their resources for their office, which are set by a commission within Virginia, are now set not only on the number of charges they bring, but they have changed the formula to now also hinge on the number of convictions. And so he was talking about how, because of that, and because they had recently been notified, their office, that they were going to lose some positions, that they have started indicting a lot more cases, and are looking to make sure that they are convicting more in those cases. And his perspective, and it may be true, was not that those weren't things that they probably should have been doing all along, but I don't know if they've not been doing those in the past. Has this created an incentive? It made me reflect a little bit upon the system we have here in North Carolina, and while certainly our resources in court are not based on the number of convictions obtained, and shouldn't be, there is, our workload formulas currently are tied to the number of charges or the number of cases that are pending in any given system. It's hard to imagine how you would do that in another way, right off the top of the head, that
Anybody have anything else to add here before we turn to questions? Okay, we're going to turn it loose to questions if anybody has a question to ask our panelists. Yes.
So Lauren just said, it talked about the charges, and Eddie just said they have to charge because there's no other way to resolve the dispute. So if there was a dispute resolution forum of some sort, then they wouldn't have to charge. So you can nip it in the butt, right?
I'll comment on an example of that. When I was a police officer in Carrboro, you can imagine with all the apartments in Carrboro that on a Friday and Saturday night, that there was always a loud noise complaint. Somebody mentioned that earlier, noise ordinance violation. And so my initial response as a responding officer was to tell folks they'd made a major mistake by having a party and not inviting their neighbors. If they would go invite their neighbors, then I wouldn't have to come back. But if I had to come back, I had no recourse. I couldn't cite them to alternate dispute resolution or anything like that. It was either charge somebody and make them unhappy, or do nothing and make somebody else unhappy. So it put the officers in a very awkward situation.
So if you had a magic wand, what would this alternate dispute resolution committee or forum look like?
I certainly haven't thought that through. I'm just saying that for officers, they generally don't have alternate methods of taking care of the situation other than making an arrest or making a decision not to make an arrest. And folks with more of a social services background probably come up with a lot of ideas where situations don't need a criminal charge, don't need a criminal conviction, but somehow you get the situation dealt with. But I don't have a model or haven't heard of one.
I think along that same line, we had a lot of people who call our office, and they were getting about disputes that they're having with people, and let's say, and I called the cops, and they won't do anything. And my response a lot of times is, well, it's probably not a crime, and so you need to, this is something civil, you need to go talk to a lawyer about whether you can take some kind of civil action. And I think that's part of overcriminalization, is where we start taking things that were traditionally in the civil context, nuisance, for instance, and we start to put them in the criminal context. Don't go out and say that Steve Walker said we shouldn't have nuisance ordinances, because that's not what I'm saying, but that is an example of something that was in a civil context that we have now moved into somewhat of a criminal context with noise ordinances and things like that. And so I think a lot of times, maybe as a society, we forget that there are civil courts as well, and that those things can be taken care of in civil courts, that not everything has to involve the sheriff's department and somebody getting arrested and going away in handcuffs.
But I think, one thing here in North Carolina, which is not necessarily true in every state, and probably deserves to be looked at, is the neighbors can go down to the magistrate office and take out warrants against each other. And the legislature did, fortunately, a number of years ago, require that those matters go through mediation before they come to court. And I think that has been a step in the direction of what you're talking about.
One of the things that callers to 911 do not want to hear from an officer is this is civil matter. That's all they don't hear. They don't hear, what are you going to do for my problem that I'm having today? What are you going to do to that person who caused me this injury or affront? And when you talk about civil court, that's hiring a lawyer. People don't understand that. The average citizen doesn't understand it. They see that as a big bureaucracy, and basically it's telling them you can't do anything for them.
Okay, Lauren just said you can send it to the magistrate's office, and they have.
Sometimes that happens. But I think, to Daddy's point, we see it a lot, Judge, probably in terms of, unfortunately, people officers being asked to respond to the scene when there's someone who has a behavioral health issue. And, the criminal justice system being used as a way to try to take care of that situation. Fortunately, there has been a growing trend with crisis intervention training and also behavioral health, emergency centers, to try to divert those folks away from the criminal justice system. I think law enforcement, to Eddie's point, they often are the people, unfortunately, who have to do something in that moment to fix it. And if they don't, quite frankly, a lot of times it's going to escalate. So it's not a matter of being able to leave it alone.
And oftentimes in a thankless way.
That's right.
Well, and I understand it, because nobody ends up happy when the cops get involved. And it's sad to think about it that way, but an impossible situation.
Yes, sir.
Lauren, I got a question on just as a prosecutor. A couple of the ideas we had up there that the North Carolina hasn't gotten to yet are looking at the mens rea or criminal intent rules or mistake law or offenses. For these sorts of regulatory crimes we're talking about, how much of an issue would that be for you as a prosecutor? I mean, to the extent you're going to deal with these sorts of crimes.
But I think the challenge is when you start looking at an issue of mens rea and criminal intent, is that you look at it in terms of a relatively narrow scope. We don't prosecute a lot of regulatory crimes in state court. There was a bill this past session that would have had a fairly broad scope, at least from our interpretation of it, kind of undermining the long historical principle that ignorance of the law is no excuse. And that certainly is something that, our Criminal Justice Foundation, our system has embraced for hundreds of years here. I think from a prosecutor standpoint, two things. First of all, generally speaking, where there is not some level of criminal intent, we're going to have a hard time getting 12 people to go along with wanting to punish someone. And so while it may not be clear in the statute that that is required, I think most of us tend away from prosecutions where you can't establish that there was some guilty conscious criminal wrongdoing on the person's behalf. I think to take that too far, though, from a prosecutor standpoint can be very dangerous, because what you're asking people to do is prove what is in somebody's mind. And that, there's certainly circumstantial evidence. There are ways that we try to do that, but at the end of the day, being able to prove what someone was thinking at the time that they took some action is a very big lift. And I think that in this area, that prosecutors generally, as you start talking about eroding intent within statutes and mens rea in general, is something that we believe needs to be pursued very carefully with a lot of the law.
Yes, Jay.
Just in response to that comment, I appreciated the point you made about trying to find 12 people to go along with it, because that speaks to the importance of the jury trial itself as a check on what we might consider to be unwarranted prosecutions, even for things that are technically offenses. But doesn't that require that jury trials actually be a sort of regular, predictable part of prosecution? I mean, it sounds great in theory, but given the rate of plea bargaining as the predominant means of obtaining convictions and the various tools that prosecutors have to in almost all cases, get people to plead guilty, isn't that check more illusory than anything else? The check of the jury trial.
Sure. So what I can speak to is, how we look at it, how I believe my colleagues look at it, but certainly within my office and our, we work very hard not to bring cases that we don't believe we can, we can encourage or get a jury to convict someone on. And we have certain ethical responsibilities around that, not to simply charge in some effort to force some negotiated plea. And so while you're absolutely right, less than 10% of cases end up in jury trial, we always go into a case with a presumption that that case may go to a jury, and with some forecast in our mind, are we going to be able to get 12 people to agree to this or not? And as a general rule, we don't bring those cases if we don't believe that a jury can convict somebody.
Is there a certain plea bargaining rate? I mean, maybe jury trials are more common here, where we practice it, and I think at least statewide it's about 90 to 80% rate. Is that number concerning to you? Is there any, or if not, is there any number that would be concerning in terms of how little role in practice jury trials actually play in these adjudications?
Sure, and so I think from a standpoint of would we like to have the resources to take more cases to trial, I think absolutely most prosecutors would say that. I'm not sure though that and it's less than 10% here in North Carolina as well. I think that there are other issues that are being evaluated as part of criminal justice reform, such as the bail system, that have as much to do with, are there ways that pleas are being, secured beyond simply a truthful analysis of the evidence or the weight of the case or the likely outcome of the case. You know, and I think, I'm not sure that the mens rea element is really the driving force in that analysis.
Yes, sir.
Yeah, and another follow-up to that, I mean, I can appreciate the sort of like difficulty with added mens rea, but might that not be okay if it's difficult to sort of make the case, like if we have a mens rea and we need to prove that somebody knew what they were doing and knew it was criminal, it's that may be all right, that it's a little more difficult.
I think when you start looking at actual, you know, specific criminal offenses and, you know, trying to make a determination as to, are you going to be able to hold someone accountable for those things? Again, going back to the issue of, you know, being able to prove beyond a reasonable doubt what somebody's thought process was. And there may be, you know, types of offenses or classification of offenses for which that makes sense. There are others, quite frankly, that the public policy of the state has been, and the legislature has made a determination that there really does not need to be, you know, that level of intent. And so, for example, driving while impaired cases. And there are certain cases that we as a community or as public have said, you know, that the danger or the risk to the community is such that certain actions in and of themselves are going to subject you to criminal liability. And so I think, you know, it would be very, and I think really proceeding upon this work needs to be done in a way that is methodical, done with everybody, all stakeholders at the table, because I think that the risk of unintended consequences when you start to paint with too broad a brush is very high.
Are there any other questions? All right, we are a few minutes early. I believe lunch is scheduled for 12:30.
And we'll take a break for a few minutes, and then lunch is out here, so get your plate and then come back in, and it should be very soon.
All right. Thank you very much to our panelists.